So let's talk about what will happen if you do receive a notice to appear. I've had multiple clients be very, very afraid that if you go to court for your hearing date, that ICE is going to be waiting for you to arrest you, right? So is this a legitimate concern? Is this a valid concern that you need to be worried about? If you are somebody without any sort of criminal history and you receive a notice to appear in court, generally speaking, ICE is not going to be waiting for you in court because the whole point of ICE is immigration and customs enforcement, right? So their whole goal is to put people into proceedings and then to get them removed from the US. If you have already been placed into proceedings, then they don't really have to do that. So if you receive a court hearing notice, you don't have any criminal issues, typically speaking, ICE is not going to be waiting for you at court. Now, if you have any sort of criminal issue, that's where things can get a little bit trickier because the Laken Riley Act, which was signed into law in January, does call for mandatory detention of persons committing or being accused of or charged with any sort of theft-related offense or any sort of offense that causes physical harm to a law enforcement officer. And that is where things get a little bit trickier. Basically, you are going to be at a higher risk. Now, if you do receive a notice to appear because your I-485 was denied, the number one thing that you need to do is you need to obtain the services of an immigration lawyer, because even if you're not detained, if you are in removal proceedings, the chances of you being able to get out and to be able to prove your case to the judge are very difficult by yourself.